To all of you. I'm delighted to extend a warm welcome. We are deeply honored to have with us the Honorable Attorney General of India, Shri R. Venkatramani, whose presence here today, after landing in India only a few hours ago from halfway across the world, provides us with the encouragement and inspiration that we need to build on all that we have learned this week and also to help us understand better the fundamentals of the bedrock of our nation, the justice system, without which no policy can be effectively executed. Sri Venkatramani's illustrious career in law spans over 4 decades, and during which he has contributed significantly to shaping the legal framework of India. As a highly respected constitutional expert and a stalwart in defending the principles of justice, his work continues to serve as a beacon for the legal fraternity, policymakers, and civil servants alike. At a time when governance, legal frameworks, and the justice system must evolve with the changing needs of society, it is imperative for us to gain insights from those who stand at the forefront of this transformation. Sri Venkatramani's leadership as the Attorney General of India, along with his extensive experience in human rights law, public interest litigation, and constitutional matters, uniquely positions him to share valuable guidance for us. As we gather for this week of learning, reflection, and growth, his perspective on the vital role of the law in public administration will offer us a deeper understanding of how we can better serve our citizens within the framework of justice and accountability. It is my great honor and privilege to welcome the learned Attorney General, and I invite him to share his insights with us.
Good evening, madam. Good evening to all the learned persons assembled for an evening of wonderful sharing, if I may put it like that. The National Capacity Building Mission is a beautiful idea. I think for all of us to build our capacities from the time we are born until the time we are able to be a valuable part of the community is, I think, never comes to an end. When you talk of capacity building from governance point of view and as an institutional element, it has, I think, some added significance. So I am indeed elated to be here today evening in my own little humble way to share insights about what we can take as treasures and worthy subjects from looking at law, governance, and the courts in contemporary India. I think I'm being asked to talk virtually everything about law, justice, and governance. This is too tall a canvas to be probably talked about or to shared within a period of an hour. Because if you are to scan the entire history of Indian constitutional law from 1950 onwards and look at how it has evolved over a period of time, both from the point of view of citizens' engagement in democracy and preserving democracy, and governance engagement in promoting democracy and adding nourishment and values to democracy, we cannot do but look at what history has been from a constitutional perspective, but also what history need to be and can be tomorrow. So it's a very engaging subject and also a challenging subject for me. But let me try to do some kind of a justice within a period of an hour to capture as much as one can do, to connect all the dots which may fall in the spectrum of sharing. One of the famous jurists or historians of English law was Blackstone. and Blackstone Commentaries in English law was written somewhere in 1765. And that was at a time when the idea of a constitution had not taken deep roots in the psyche of people across the globe. Just 24 years later, in 1789, the US Constitution came to be ratified by 13 colonies. Now, US is now talking about almost 235 years of its constitutional existence. We have roughly 3/4 of this period as we celebrate our 75 years of constitutional existence. The vast literature on the evolution of legal systems in ancient India, Mesopotamia, Rome, China, and for example, other certain other countries, are all about ethics and code of human conduct and how a centralized authority will go about ensuring justice. They were all, however, built on relationships in a hierarchical social order. In a very rudimentary sense, these were beginnings of rule of law, though not in the ways of contemporary understanding of rule of law. Today, we are talking about constitutionally ordained principles towards moving away from hierarchies in a social order. Any discussion about judicial systems today will be about constitutional role of the systems. While the major role of courts in settling private dispute remains, as the task of the courts, constitutions generally have brought about another important role for courts, namely resolving issues between citizens and governments. Now, judicial systems in all the civilizations we talked about, including England and the rest of Europe, were all about private dispute resolutions. The laws of contract, the laws of property were the most prominent subjects. The great agreement between the king and the subjects in England, called the Magna Carta, when claimed has slowly led to the great revolution in English law, slowly led to the king-made subject responsible for the liberty and property of people. The government being sued in a court or made subject to court-made resolutions is partly traceable thereafter to the principle of legality of all laws and governmental actions under these laws. The English administrative law is all about this. But we have two legality domains today. Now, one, the administrative law legality, and another, constitutional law legality. Both operate on different set of rules and principles. Administrative law legality is about principles of natural justice, fairness, rules against bias in public functions, etc. Constitutional law legality is about all governmental actions being subject to fundamental rights. It may be of interest to know that the powers which our courts exercise today are not expressly conferred as judicial review power on the courts. In the famous Madbury versus Madison judgment, hailed as the foundation of judicial review, the US Supreme Court long ago said that it's the province of the court to say what the law is. This has become the mantra for authority of courts to deliberate on the legality of legislations and virtually all governmental actions. Today, it is said that saying what the law is not merely declaration of law, but making of law as well. Declaration of law is interpretation, as we all understand, but making law will mean enunciating principles and laying down meanings of law, not expressly stated in the law. Where do we locate this power of the court? What is the scope of the doctrine of separation of powers and its applicability? In the context of challenges to public policy enunciations, such as the extent of reservations in public appointments, say beyond 50%, or land reforms towards an egalitarian social order, or say electoral bonds, or even grant of citizenship to certain class of people, or to permit foreign direct investments, etc. These are all matters of great importance for what governance can do and cannot do. Before we go further, let me take you into another important aspect of our constitutional evolution. if I may put it like that. One of the milestones was the Keshavananda Bharati judgment. The court said that the basic features of the constitution cannot be amended. Two important aspects need to be looked into before we go further. One is the process by which constitutions come into existence, and the other is constitutions, how constitutions endure over a period of time. In the late 18th and early 19th century, surveys indicate that more than 170 and odd constitutions came to be drafted, came to be amended, and came to be followed. But how many of them have a constitutional endurance as their core, value of existence? The answer is very uncertain. As you see in contemporary times, many constitutions have not endured and have probably suffered several setbacks, both beyond the constitutions and within the constitutional rules themselves. We see both our neighbors having these problems. So several other countries in Asia, like Korea, Thailand, etc., have been grappling with institutions of the extent to which constitutions can be amended, the way in which constitutions can endure, so on and so forth. Therefore, constitutional endurance is strictly related to how constitutions are operated and how within the constitution, how institutions make the constitution effective and important for people. For instance, democracy. I'm sorry for the interventions. Am I audible, madam?
Yes, sir. Yes, sir. We can hear you.
Okay, I'm so sorry.
Please go ahead.
So I was talking about constitutional endurance as an important dimension in any constitution. We will look into it presently as you go further. So, and I said one of the milestones was the Keshavananda Bharati judgment. The court said that the basic features of the constitution cannot be amended. This basic structure doctrine has in a way added strength to the judicial review power of the court. When Parliament thought that many legislations can be kept away from judicial scrutiny by reason of what Parliament learned in the early stages of a republic in the 1950s, so Parliament thought that many legislations can be kept away from judicial scrutiny by putting it in the ninth schedule referable to Article 31B and 31C of the Constitution. The court said that even that determination by the legislature can be scrutinized by the court. Does it mean that the court can say no to any determination by the legislature or the executive government? I may say no. Let me look at it a little more in depth. But all this I talk seems like great stories about the idea of law and the impact on society generally. In post-19th century, we began to talk about constitution as the foundation of all laws, the making of laws, the execution, and their justification. So I find that making of laws, the execution, and their justification are important elements of democracy, and as equal important elements of the power of the court to look into them, and also more fundamentally, the engagement of the people in knowing how laws are made, how laws are executed, and how laws are justified in public forum, in legislature, and in courts. So this means that the Article 13, let's look at how does it happen in our Indian Constitution. Article 13 of the Constitution provides that the state shall not make any law which abridges any of the fundamental rights under Part 3 of the Constitution, and that any law made which so abridges such fundamental rights will, to the extent of contravention, be void. This means, again, particularly in the context of Indian Constitution, like several contemporary constitutions like South Africa, or some of the East European constitutions which have emerged after the collapse of the Soviet Union, that the courts will begin to exercise a certain degree and nature of power in furtherance of fundamental rights and their meaning and their existence and their promotion. In the Indian Constitution context, we have Articles 32 and 226 of the Constitution, which confers power on the Supreme Court and the High Courts to, to inquire into whether any state action is in conformity with the fundamental rights chapter of the Indian Constitution. So in the exercise of this power, what can the courts do? The court can declare that a law is inconsistent with the fundamental rights and therefore it is void, which means the law is unconstitutional. I digress here for a few seconds. When A.K. Gopalan in the early 50s was complaining about his detention and the preventive detention laws, the argument was Article 21, which says that no person shall be deprived of liberty, life and liberty, without due procedure of law. His argument was that the Defense of India rules were in violation of Article 21. The Supreme Court then thought that the due procedure part in Article 21 meant only that there has to be a procedure. As long as there is a procedure, Article 21 stands complied with. The court did not inquire into a further question whether the procedure itself must be just, fair, and reasonable. So the story of Gopalan ended there. But much later in 1978, what became another cornerstone of India's constitutional history is the Maneka Gandhi case. In Maneka Gandhi, court went further and said, for the purpose of Article 21, it is not really any procedure that will satisfy Article 21, but any procedure must be just, fair, and reasonable. From this statement of constitutional law, something further emerged. What is that? It now transpires that any state action, which means legislations, governmental decisions, even customary law, and how law is defined in Article 13 of the Constitution, any one of those actions, if they are in contravention of fundamental rights by reason of lack of fairness, lack of reasonableness, or lack of justice, can become victims of being struck down as unconstitutional. So therefore, today we have the canvas for the courts to inquire into what is the legality fundamentals of a state action has become very wide. Is it problematic for governance? It's a very important question. When we talk of capacity building, we enter into how governance institutions can look at the Constitution on the one hand, and then say what the Constitution commands us to do, and also look at what, by learning from constitutional experiments, not only in India, but the rest of the world, in terms of economic orders, in terms of political theories, in terms of ideological orientation, and all those very important emerging principles of public policy and governance today. So keeping constitution on the one hand and public policy making on the other hand, how do you really navigate between these two is a very important question. And that's why I think when you go back in point of time in the US constitutional history, when the US Supreme Court is only talking about legality from a very narrow angle, and today legality has expanded in so many dimensions. Examples are whether the government can take a decision in relation to, let's say, environmental laws, in relation to sustainable development. So what kind of principles on sustainable development will stand the scrutiny of courts? And if so, on what parameters will the court test them? Or for instance, they said foreign direct investment. Now, I suppose across globally, no part of the world, except perhaps even communist China, stand in terms of a controlled economy. In communist China, of course, it's a state control, but a liberal economy. So we have a situation today when free markets, free trading in ideas, free exchange of resources, innovations, creativity at the individual and collective level are important values, even moving towards an egalitarian society. Of course, we have all those very important critical statements by political economists who talk about inequality continuing to be a major concern across the globe. Inequality in economic field, inequality in status, inequality in accessing public resources, so on and so forth. But then I suppose today we are certainly convinced that by a controlled economy or controlling human thought, human creativity, human innovation, and therefore ability of people to create wealth by innovation, creativity can be controlled by the state at all. The more we control, I think the less it makes sense. Therefore, but in the other in other aspects, control has now become regulation. So if control is no longer control in what we understood in a dictatorial society, but regulation in different forms and means, that's where we probably have all those apparent conflicts between governance through lawmaking in the legislature assemblies, governance through lawmaking and policy making at the executive level, and governance in justifying policies already made in accordance with what we think is constitutionally done. So this is an area where I suppose as we move further, the next couple of decades, we will know that we would have evolved into new theory of judicial power, new theory of role by the courts, and where perhaps there'll be probably a merger of institutional decision-making policy, determinations and scope, etc. I'll talk about it a little later, but before I do that, I also thought that we should probably look at few other aspects. There's a lot of burgeoning literature and why democracies fail or why politics fail and so on and so forth. They have emerged in varied contexts, in varied political dimensions across the globe. But I suppose all discourses in law, political science, or social sciences need to revolve around definitions, concepts, and ideas. And where do these definitions, concepts, and ideas come from? And if we take very important lessons from controlled societies where definitions, concepts, and ideas could have come only from a party or an oligarchy or a set of institutions, then we have now learned that cannot be so. Definitions, concepts, and ideas cannot be and need not be the only preserve of people who belong to one political party or one ideological doctrine or one set of institutions. So we therefore talk about the plurality of the coalescence of plurality of values, ideas, and therefore concepts and definitions. Law is all about definitions, again, concepts and ideas. That's why we talk about public policy can be seen from various angles today, namely economic, fundamental rights, social justice, social order, national sovereignty, and currently global impacts and factors. We talk about sustainable development. Now, all public policies can therefore be likened to concentric circles, but internally connected and impacting each other. For instance, policy on education has relevance to equality, equal opportunity, gender justice, status, individual fulfillment, and employment too. Similarly, policy on health has impacts on longevity, maternity benefits expansion, leading to child health care, equal access to health care, and even disaster management situation, etc. Policy on rural employment and development has dimensions of balancing rural-urban growth, then panchayats as self-governing units, and local democracy policy on the environment as implications for industrial expansions, health, and urban as well as rural planning, as also transportation. Policy relating to water resources has concerns of sustained development, then policy on agriculture has impacts on food self-reliance, balancing imports and exports of food items, and many of which have interconnections with world trade agreements and multilateral treaties. Therefore, today we'll talk about sustainable development. We also talk about, let's say, a recent controversy where the Supreme Court asked the government to have a national policy on genetically modified, subjects. So, how in all these aspects of public policy, the question that will fundamentally arise is, on the one hand, the freedom, the degree of freedom, the need and the desirability of innovations by individuals, institutions, and governments as institutions, the need for innovation, and the desirability on making the life of people better and good on the basis of common good, etc. On the one hand, and how will courts as intervening bodies will look at and to what extent can say and sustain them or say no to them. So I understand that if you look at how the debate between courts in England, where England does not have a written constitution, English people still say we have an unwritten constitution. And the whole of English administrative law is all about how, in unwritten constitutional domain, there can still be rule of law and can still be intervention by the courts and looking at how executive governments must act within the domains of law made by Parliament. The English courts certainly do not have the right to say no to a law or to render a law unconstitutional because there is no such power exists for the English courts. But today, across major constitutions, the power to say, the power to declare a legislative action or executive policy decision as unconstitutional is found in many constitutions. The South African constitution says judicial review power is part of the constitutional structure. So therefore, for public policy making, the more important question is, how do we really walk this tightrope? Now, there is no one clear answer to it, in the sense that probably constitutions could not have said where would the role of the court begins and where would it end. So in the recent past, the Supreme Court has virtually engaged on various issues of affairs of life of Indian people, from matter relating to marital life, from matters relating to gender discrimination, from matters relating to how elections will be held under an independent election body, or even we went into the question of how appointments of judges will be made to superior courts. So the engagement of courts in these matters and the degree of engagement, on the one hand, is seen to be expanding and subjected to various aspects of critiques on the ground of what in common parlance legislatures and executives talk about the Lakshman Rekha line. But I suppose we need to go beyond that very pedestrian way of looking at that. Why do I say that? Now let me go back into some very interesting things which have happened. For instance, in what's called the blunders which governments can make in public policy decisions or in lawmaking. In a very interesting book on the subject concerning what happened in England, the book picks up a number of legislative and policy decisions which were called blunders. So I'll give you a few examples here. The mid and the late 1980s in England witnessed a sharp increase in crowd disturbances at football matches in Britain and overseas. In 1985, in a riot between Birmingham City and the Leeds United fans, caused the death of a teenage fan when the wall collapsed. Soon afterwards, crowd violence at the Heysel Stadium in Brussels led to the death of 39 spectators attending a Juventus-Liverpool match. Thatcher's government responded by introducing a football spectators bill, which reached the statute book in 1989. The new legislation provided for the creation of a football membership authority, which would administer a new national football membership scheme. We are, for instance, witnessing the BCCI debates both inside and outside the courts here. In April 1989, with the government's bill well on its way to the statute book, 96 Liverpool fans were crushed to death in an incident at Sheffield's Hillsborough Stadium. Like the Football Spectators Act, which came to be passed but never became an effective law. I give another example. There was the passage of a Dangerous Dogs Act of 1991, which was an event after a media-driven affair. So there are other such very important examples in England. For instance, in 1975, the British government enacted now a long forgotten Community Land Act, which costed millions and achieved nothing, according to surveys. Then we had another post 1964 Labour government decision not to devalue the pound. Ministers were divided on the issue, but Prime Minister Wilson and the Chancellor of the Exchequer, James Callaghan, were adamant that devaluation would damage Labour politically, tarnish Britain's international reputation, and relax the economic pressures in British industry to reform and modernize itself. From late 1964 onwards, Prime Minister Wilson forbade ministers from discussing even the remote possibility of devaluation. But the financial markets had other ideas. The financial market decided that whatever the government might think, the pound was overvalued and would have to be devalued sooner or later. So these are matters which are beyond the control and the capacity and competence of governments to think, ponder, and talk about. Therefore, eventually, in November 1967, amidst mounting market pressures, the Prime Minister did devalue it. Callaghan felt honor-bound to resign as Chancellor. Wilson, as Prime Minister, clung on to the position. This is what the book talks about. So we have very interesting instances in Britain. Probably if you do a survey of such blunders which governments do in other parts of the world, we will have a very rich chronicle of how policy making can go wrong for reasons of um, or meeting with public populist demands. So it takes me to a very interesting contemporary aspect, namely a freebies basket, which is freely offered by political parties, which is now becoming a permanent item of our political party manifestos. I understand that party manifestos cannot be beyond constitutional limitations, and no electoral promise can be a private plunge into public funds. If laws can be tested on constitutional grounds for their validity, party promises on electoral manifestos cannot be immune. When policies such as freebies do not promote righteousness, resonating with ethical norms and cultural roots, and sound financial fiscal discipline, I'm suppose these policies will not stand as dharmic flags for social change. Unfortunately, on the freebie issue, Supreme Court had earlier said freebies are part of our part 4 of the Constitution in promotion of um, uh, values which promote equality and egalitarian values, etc., the directive principle state policy, as it said. I do not know whether this reasoning of the court is sound and perhaps need to be revisited. Therefore, what is important in such a context is that we need to say the distance between buying votes and buying minds is not too big. And how do we go about talking about it? So I thought I'll draw your attention to all this only to look at where public policy making, which is an important aspect of governance and which needs immunity from slow scrutiny, because the more the scrutiny by the court and the greater the deliberation by the court on the minutiae of policy making, then there is an element of uncertainty for democracy, as some political scholars seem to be arguing. Well, I think it's important for us to look at it from a different perspective as well. If you just imagine that after the Constitution of India was adopted, and we did not have Article 13 in the Indian Constitution, one looks at what would have been the effective positioning of fundamental rights in the Constitution. They would have remained as fundamental rights, but without being probably checked by a scrutiny which will balance state action, legislation with reference to fundamental rights. Therefore, if Article 13, in fact, adds a significant essence and value to the Constitution, we keep asking about why is that? Certain other countries in the world, particularly, say, a country like Communist China, and where dictatorships of one party rule prevail for a period of time, could continue to hang on to a system where the role of the courts is minimal. We have a lot of political debates on this question. In the post 1948 Universal Declaration of Human Rights era, The great debate was between the social, economic, and cultural rights and civil and political rights. And this debate was in the context of the Cold War and the great debate between free market capitalism and the socialist ideas. I have one thought in this context. If in the context of a socialist doctrinal socialism, what led to its importance was probably, if you can recall, a famous statement made by Karl Marx in his Communist Manifesto, that philosophers have only hitherto interpreted the world, but the point, however, is to change it. The question that became an important plan for socialism is changing the world. But the question is, who will change the world? On what parameters? How will you bring about what changes? And if changes are good or bad, who will question them? What kind of systems can this questioning happen? So if changing the world means correcting your mind, my mind, and asking all of us to be part of our minds to be tuned by somebody else who will dictate us what should be our mind, then we have huge political, philosophical questions. Therefore, the changing the world has become an important question to be debated within the contours of democracy. So if you look at changing the world from outside democracy, we have different outcomes. If you talk about changing the world from within democracy, we have entirely different outcomes. Therefore, changing the world within democracy means evolution of contours of democracy themselves and evolution of institutions to keep on responding to the question of how do we effectively, meaningfully change the world around us, including our personal, social, public relationships, our transactions in the economic field, in the political arena, and in the cultural area, religious, faith area, etc. Therefore, how do we keep changing ourselves? So important aspect, therefore, for us is to say no forever, to say no forever to somebody telling us that we will be the masters, your thoughts will be the masters, how you will guide your minds and how you will think and how you live, you make your affairs of life. If you say finally and effectively to know this, no to this, then comes the question is, how do you really fashion new institutions for effectively making people to freely transact their affairs of life, to fully transact their understandings and sharings of thoughts, ideas, etc. And this is what the challenge lies for democracy. And I suppose 75 years of Indian constitutional history is a great value addition to how India has been able to manage without large frictions in its institutional functioning, without large frictions in the fundamentals of democracy. So when you go outside and talk about Indian values of democracy, we talk about, I say, the endurance of the Indian constitution from this very important fundamental that the Indian democracy, the role of the court, and the ability of the parliaments and the executive to enact public policies and to have a certain free exchange of domain of exchanges, and which makes it very different. So if between 235 years of US constitutional history, maybe about 15, 20 years ago, leading academic scholars in US wrote a book called Constitution for 2020. I looked at that the kind of thoughts which are gathered in that book. They were still talking about how democracy must make sense for the mass of the people in three or four fundamental senses. That we are ensured and assured that we are participants in democracy. And how is that assurances made available to us? And what kind of institutions can grow and evolve subject to all those fundamentals? Now, that takes me to another interesting question. I scan all the constitutions of the world as they exist today. In almost all the major constitutions, we have superior courts called constitutional courts or supreme courts, which are given powers to review what governments can do, including what legislatures can do. And in the early 1990s, scholars across the globe began to talk about global expansion of judicial powers. from one angle, they were probably talking about something very new. From another angle, they were talking something only from a different dimension. A different dimension in the sense, in major parts of Europe, courts were only engaged in ensuring that governments function within what is called the leading strings of law, that you function within the law you make, and you shall not act ultra vires the law. To that extent, the courts had enormous powers. They could say a government has failed to act within the strings of law, or her actions are ultra vires the law, by adding several norms of, as I said, principles of natural justice, fairness, lack of bias, etc. But when we moved away from this very narrow concept of the ability of the courts, we now looked at a vast domain freely available to courts. That's why this debate seemed to be something open-ended. But I do not know whether it is such an open-ended debate in an alarming sense. So for constitutional lawyers and scholars, it is staple fiber. We talk about because one school of thought will say the courts will have to draw a line, a very clear line, and not go beyond them. Other set of lawyers will say if the courts do not say what the law is, if the courts do not say declare what the law is, then where will be the essence or value of democracy? And which means fundamental rights, which means ultimately the question is who says what exactly is the content and meaning of a right? And today there's a major debate. Who says what exactly is the value or the meaning of freedom of speech and expression? Who says what is the meaning and content of right to trade and exchange and commerce? So we have this very more important freedom of speech and expression and right to freedom of trade and commerce. Leave alone other fundamental rights and which are probably connected to it, peripheral or otherwise. Therefore, these two important fundamental rights virtually seem to be shaping not only our democratic debates, but also how governments can function. I thought one needs to look at how there is a important need for emergence of public institutions which can probably build the gap between citizens' effective participation in democracy and government's ability in making public policies and public policies which are relevant and sustainable. So relevance and sustainability of public policies and their relation to democracy and their what called the compatibility with fundamental rights, but more importantly, how citizens feel they're connected to public policy making. So I think it's important for us as the National Capacity Building Commission to keep talking more and more about all these aspects, not merely of law, not merely of constitutional law, but more importantly of law, constitution, democracy, political theory, doctrines in political theory, etc. Now, as I scan the wide range of subjects which have been discussed from 19th onwards, it gives me a very interesting bouquet. How ranging from how do we look at our own minds? I found Sri Ravi Shankar addressing this audience, and very important scholars in a wide range of public fields who have addressed this audience and gathering. And what a connectedness! I feel this connectedness is something very important. Then when I was asked to talk today about courts, law, governance, etc., I had a little what called reservation. In sense, how do I, at the end of the day, when all the other great people who have addressed you have taken you to different realms of thought, mind, and all that, how do I bring in law and justice? Where do they figure? So I had sort of some kind of reservation, and I had to work a little to find out how do I bring in law, justice, and governance in the midst of this very wonderful collection of subjects for discussion from the past 19th October onwards. So as I was traveling abroad and coming back today and sitting with my iPad on my while traveling, I tried to gather a few thoughts today to find out what I can do to do some minimal justice for the subject given to my talk before you. But I think before I go further, it will probably useful if maybe important to add value to today's sharing. That if I can answer some questions, and also I want to conclude by one observation. For me, as a practicing lawyer over a period of time, having looked at and having studied political theories and political doctrines and their growth, their existence, their decay, or their disappearance across the globe. What is important, I think, is one, the value of each and every individual to feel that my ability to innovate, to create and add to the general wealth of the community is something non-negotiable. I think something so non-negotiable that no governance, no political theory can take it away from each and every one of us. But when you talk about this importance value for the individual, it becomes more important if I'm able to connect to the community. My ability to innovate, to create for the wealth of the community and the values in economic, social, and the political field that can be created by this freedom and liberty assumes another heightened level of importance. Therefore, individually and collectively, the freedom to innovate and create is something fundamental and so important. So if governance and the courts can play their respective roles in ensuring that both as individuals and as collectives in a nation, we are able to have this innovation freedom manage a beautiful wedlock. I think there the role of the courts and governance would have done their job, and perhaps that's how we look at it.
Thank you so much, sir. First of all, deep gratitude that you landed in Delhi just a couple of hours ago and you're here with us to give us a sense of life way beyond the law. And I think your talk for government officials who are watching this, who are on the sort of cutting edge of policy, it's amazing how you took us through the whole first historic sweep and then presented the challenges of both the legal profession and public policy. And, you know, this fundamental question of who defines the right, to me, becomes very important in a democracy. And I think after hearing you, there's a lot of food for thought of what are the ways in which we engage as citizens and what are the ways we continue to build on the shoulders of those who have nurtured this democracy. Lots of questions, but
Okay.
I'll keep them so that I know you must be exhausted, so we won't.
No, we can go on, no problem.
So one question, how do you assess the current state of India's judicial system and what are its most pressing challenges?
This question will require writing a whole book about it. In the sense that for more than, I should say, for more than 200 years in US constitutional history, you will find a vast literature. It all began by people talking about 9 judges sitting in the court saying what is good for the country, unelected judges. Then people began to talk about government by judiciary. So government by judiciary means the entire responsibility of not only making law for the community, but enabling people to determine what could be good for them. So for long in US, the abortion law occupied the attention of the court. The other more important engagement of the US Supreme Court was the racial desegregation issues. In 1954, in Brown versus Board of Education, the US Supreme Court talked about how it is anti-US Constitution to talk about racial segregation. But much 30 years later, instances kept coming before the US Supreme Court about how, in the field of university education, segregation continued to exist. So when you talk about these aspects of any society, look at what's happening in Europe today. Either during the pre 1948 period in Nazi Germany, with all the anti Semitic attitudes, which in a different way continues to exist today in Europe or elsewhere, or any other idea of anti faith or anti religious feelings, these fundamental identity issues cannot be properly resolved by law. They have to be resolved by people deliberation more and more and more. But when it comes to, say, discrimination on the basis of caste or religion or faith, and talk of discrimination meaning access to public resources, access to natural resources. When we talk of resources today, we have an interesting provision in the Constitution, Article 39A, which talks about that the material resources of the community shall be so distributed as to subserve the common good. So a question arose at some point of time, what does this material resources mean? Does it mean only natural resources or also man-made resources? The Supreme Court of India answered it very, I think, very intelligently that this meant not only natural resources, but man-made resources. I suppose in a civilizational stages, we have moved far away from looking at resources as only natural resources. We make life possible by engaging ourselves with natural resources and by generating man-made resources. Therefore, both natural and man-made resources must be equally accessible to all people. But how do you make it equally accessible? We talk about equality of opportunities. At the same time, we say equality of opportunities does not mean equality of outcomes. So we fall back on this very important distinction. We ask this question, what I have in mind is the answer, namely, that if communities can exist on a peaceful basis and a shared social basis, then resources of the community must be made available to all, and resources must also be made through an open and unconditional participation of people, through an open and innovative, creative participation of people in generating resources. So we are all talking about resources. So the role of the courts in that will be that, all right, if there is a discrimination on the basis of people's ability to create resources and access resources, I will come in and step in. But in what manner governments can enable and facilitate people to create resources and create wealth, then perhaps that will be a policy area which courts should not enter into at all. Because that's a policy area where experiments are important. That's a policy area where governments and people's deliberations are important. I don't think that's an area where courts can have standards by which they can say, do this or do not do this. That will be my answer.
So one question has come in, and I think you must have heard this one before. How can the judicial system in India become more accessible and efficient for the common citizen, particularly those in rural and marginalized communities?
This question had engaged both the Constitution and the government ever since Article 39 was enacted, saying that the justice system must be accessible. So we have evolved a very vibrant legal assistance scheme across the country. This legal assistance scheme now is more than 30, 40 years. I remember in early 80s when Justice Krishnayar in his Bhagavati gave an important report on legal aid. Almost all the states have enacted legal assistance policies and schemes, which have expanded very importantly. And I should say, probably the legal assistance scheme in India is much more expansive and much more, I'd say, quality addition to what call people's ability to access justice. Accessing justice is now treated as a fundamental right. But then how do you really make it effectively happen? But one should also say that because of a variety of reasons where we have a certain court systems which function on adversarial basis. As long as we have adversarial basis court systems, we need physical buildings of courts, we need lawyers practicing in the courts, we need many other infrastructure associated with the adversarial system of courts. To make people and to enable people to get connected to the adversarial system, I think would also ended into several handicaps. But now, since we are now moving towards a digital system where access can be made not necessarily through this physical infrastructure. Now, what's called the digital infrastructure is a very important development in technology.